a council member lived one block inland from a proposed development that would block his ocean view and had a history of personal animosity towards the applicants because of the project. So right away, when you hear that they're one block away, and you think of a city like Hermosa Beach that has very small lots, the conflict of interest laws immediately come to mind, right? So you have that. So in that case, obviously the court was pretty straightforward. The council member's personal interest made impermissible bias because of conflict of interest, but also the demonstrated animosity against the applicant also it constituted impermissible bias. So the takeaway in that is decision makers must avoid both personal conflicts and the appearance of bias. The next case we're going to talk about is Woody's Group Incorporated versus City of Newport Beach. This is from 2015. And in that case, a council member filed an appeal of a planning commission decision he publicly opposed and dominated discussions during the council's hearing on the appeal. The court ruled that the council member's pre-hearing statements and actions before and during the appeal hearing demonstrated an unacceptable probability of bias. So again, the takeaway on this is statements and actions that suggest a predetermined outcome can invalidate the decision. And by the way, I'd like to point out also, it's not just statements that you make as soon as you're elected, right? So it's a little bit iffy if it's for statements made during a campaign or before you're appointed or elected to a position. But if there's been court cases where it's gone both ways. So it's a little bit of a gray area there